Hello, everyone, and welcome back to Law Unlocked, the podcast where we break down complex legal concepts and show you how they impact today's world. Let's start off with the basics. So, force majeure is a French term, which literally means superior force. In legal terms, it's a clause in a contract that frees parties from performing their obligations when extraordinary events beyond their control occur and happen. So these events are typically unforeseeable and unavoidable and essentially inevitable. And think of something like natural disasters, pandemics, or war. And we've seen this before with the COVID-19 pandemic and now in times of unforeseen conflict. So if a force majeure event happens, a company might be excused from fulfilling a contract, or at least its liability may be limited. But here's the tricky part. The application of force majeure, let's say it in a French accent, shall we, depends heavily on how the clause is written. Some contracts list specific events like floods, earthquakes, or acts of terrorism. Others are more general, and they give room for essential interpretation. So let's see how this would play out in terms of the war. So let's zoom into it. So we have global conflicts like the ongoing war, for example, in Ukraine and Russia. And these are creating real challenges for businesses. Supply chains are disrupted and shipping routes are blocked and contracts are impossible to fulfill. For example, let's picture this and imagine a European manufacturer that has promised to deliver goods to a company in another country. Suddenly, due to military action, transport becomes absolutely impossible. Can the manufacturer invoke a force majeure clause? Often, yes, but only if war or armed conflict is included in the contract's definition, or if courts interpret the clause broadly. Here's an interesting nuance. Economic hardship alone is usually not enough to trigger force majeure. So if a company faces rising costs due to sanctions or inflation caused by war, it may still be held liable unless the contract explicitly covers such consequences. Then let's look at our legal implications and liabilities. So what happens legally when a company invokes force majeure? So we have excused performances. The company may be temporarily or permanently avoided to fulfill its obligations. And there is a lot of suspension and termination. Some clauses allow for suspension of duties, the force majeure event ends, and others permit contract termination. Then there is something we call the burden of proof. The company claiming force majeure must usually prove that the event directly prevented performance and that they took reasonable steps to mitigate the impact. So courts can scrutinize these claims. For example, if a company could have rerouted supply chains or found alternative solutions, the force majeure defense may fail, as you would say. Let's use a little bit more of recent examples. We have been through a lot as a society, and during the COVID-19 pandemic, many companies tried to evoke force majeure when lockdowns disrupted supply chains, some successfully, some not, and that just basically depended on the contract wording and the local law. Similarly, if we look at the ongoing wars, we can see that there's many claims that are arising across industries. Shipping contracts, manufacturing agreements, and even energy supply contracts are affected. So if we look at this in terms of the courts and the arbitrators, they are now dealing with a wave of disputes over whether these disruptions actually qualify for it. So if you are a business owner, you really need to essentially understand that drafting your contracts carefully matters more than ever. Clauses must clearly define what counts as force majeure and what obligations do remain, especially in extreme circumstances. So what can you listeners take away? What advice can you take away from listening to what I have told you? Well, always review your clauses carefully and recognize that political unrest and sanctions are increasingly relevant triggers. Understand that force majeure doesn't automatically erase obligations. It can limit liability or delay performance, but it's rarely a free pass. And finally, document everything. Now, I'm saying this again, document everything. If a company wants to rely on force majeure, evidence that the event directly caused non-performance is, I cannot actually say this enough, it is critical, all right? So, force majeure is a powerful legal concept, but it's also complex. In today's volatile world, businesses need to understand it more than ever. Whether they're navigating a pandemic, a natural disaster, or the devastating effects of a war. So, that is today's episode of Law Unlocked. I hope you enjoyed this essential breakdown of the entire notion or concept. And make sure to subscribe so you never miss an episode. And from next week, I will be diving into another topic. You can comment if you would like me to do something more specific. But trust me, it is going to get more interessante. Where I have gotten my sources from. Because as they say, research is absolutely key, especially when explaining concepts to others. So I have done immense research, looked up articles, done some annotations, and created those detailed notes. So I'll be putting that if anyone wants to go check that out as well. So thank you so much for listening, and remember, knowing the law helps you unlock the world and society around you.